Here's something that catches a lot of people off guard in Virginia. You can have high THC levels in your blood, get arrested for DUI, and still have the entire case dismissed in court. That sounds contradictory, because it is. And yet, it happens. But only under very specific legal conditions that most drivers, and frankly many attorneys, misunderstand. What makes this legally interesting, more accurately, legally dangerous, is that Virginia does not treat cannabis impairment the way it treats alcohol. The assumption that numbers equal guilt quietly fails here, and the consequences of misunderstanding that failure show up later, in enforcement and courtrooms across the Commonwealth. And that's where this becomes complicated. Most people believe that if a blood test comes back showing THC, especially a high number, the case is over. That belief feels logical. It feels scientific. But under Virginia law, it is not how impairment is actually proven. And that gap, between what people think the law does and what it actually requires, is where cases are won, dismissed, or quietly reshaped. Now, that matters. Because the penalties tied to a cannabis DUI in Virginia don't disappear just because enforcement is confusing. Let's slow this down and walk through it carefully. There's a counterintuitive legal fact in Virginia that doesn't get enough attention. There is no per se THC limit for driving. None. Not 5 nanograms, not 1, not 0. Virginia lawmakers deliberately chose not to create a numeric threshold the way they did for alcohol at 0.08. Instead, Virginia uses a very different legal standard. And that choice ripples through every DUI stop, every blood warrant, every forensic report, and every courtroom outcome. That difference is subtle, but it's everything. Here's the belief most people carry without realizing it. If the state can show THC in your system, especially through a blood test ordered by a judge, then impairment is assumed. That assumption feels reasonable. It's reinforced by how alcohol cases work. It's reinforced by how police reports are written. And it's reinforced by headlines that flatten nuance into certainty. But under Virginia law, that belief doesn't survive contact with the statute, or with forensic testimony. And that's where enforcement begins to diverge from expectation. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. Today, we're examining Virginia cannabis DUI penalties and court cases, with a specific focus on how impairment is proven, how blood tests are used, and why certain cases collapse even when THC levels appear high. This is not legal advice. We're not discussing how to avoid enforcement, how to consume cannabis, or how to challenge a charge. We are strictly analyzing statutes, court standards, and documented enforcement outcomes within Virginia. And to do that properly, we need context. Virginia's cannabis law evolved in pieces, not as a single unified system. Decriminalization, medical cannabis authorization, hemp legalization, and impaired driving statutes all developed on separate tracks. And those tracks don't always line up cleanly. Driving under the influence is governed primarily by Section 18.2-266.1, which focuses on impairment, not presence. Meanwhile, forensic science around THC has advanced unevenly, especially when compared to alcohol testing. So confusion is common. Law enforcement operates in real time. Prosecutors operate under evidentiary burdens. And courts rely on expert testimony that often acknowledges scientific limitations. That gap creates uncertainty, and uncertainty produces inconsistent outcomes. And that brings us to how the law actually works. Virginia's DUI statute does not ask whether a substance is present. It asks whether a driver is impaired to any degree while operating a motor vehicle. That phrase, to any degree, sounds expansive. But legally, it places the burden on the Commonwealth to show observable impairment, not just chemical detection. Let me rephrase that, because this is where people get lost. A blood test can show THC. A lab report can show numbers. But those numbers, by themselves, do not legally establish impairment under Virginia law. The statute does not convert chemistry into incapacity automatically. DFS scientists have acknowledged this repeatedly. In sworn testimony, Virginia Department of Forensic Science experts have stated that THC levels in the bloodstream, even when high, cannot be reliably correlated to impairment without additional context. That matters, because that matters legally. Especially when you introduce edibles. When THC is consumed in edible form, the timing of impairment can lag hours behind ingestion. Blood levels may peak after impairment has passed, or before it begins. More accurately, the timeline becomes nonlinear, and forensic certainty collapses. And that uncertainty shows up later in court. Now let's talk about enforcement, because this is where expectations collide with reality. DUI enforcement typically begins with a stop, followed by observations. Field sobriety tests are often used, but not always. If a driver cannot perform them due to medical or physical limitations, officers may rely more heavily on observations, drug recognition expert evaluations, and ultimately, chemical testing. Blood warrants are common. But here's the thing, lab reports are not determinative. They are evidence, not conclusions. Prosecutors still must connect those numbers to impairment at the time of driving. And when that connection can't be made convincingly, cases stall. Which brings us to a real Virginia case. Earlier, I mentioned that contradiction, high THC, no conviction. Now let's return to that. In Fairfax County, a driver was stopped after being reported for possible erratic driving. The driver had documented orthopedic issues that prevented participation in field sobriety tests. Officers obtained a warrant for a blood draw. The results showed high THC levels, along with therapeutic levels of a legally prescribed medication. At first glance, this looked straightforward. But in court, the defense challenged the prosecution's ability to prove impairment. A Virginia DFS scientist testified that, even with high THC levels, they could not correlate those numbers to impairment without knowing the driver's tolerance, method of consumption, or timeline. The scientist acknowledged that edible consumption could mean the last ingestion occurred hours earlier, disconnecting blood chemistry from driving behavior. The result? The prosecutor dismissed the case entirely. This is where that issue becomes clear. Virginia law does not punish chemistry. It punishes impairment. And when impairment can't be proven, the case collapses, regardless of THC levels. Now, that doesn't mean cannabis use is permitted while driving. It means the evidentiary standard is higher than people assume. And that distinction changes everything. Who does this affect? Consumers, especially medical cannabis patients, often assume legality equals immunity. It does not. Certification is not a defense to DUI. Retailers face reputational and policy fallout when enforcement narratives oversimplify impairment. Local governments struggle with public messaging, because state law doesn't translate cleanly into sound bites. And the medical cannabis framework exists alongside DUI enforcement, not above it. Each of these groups experiences the same statute differently, and none are insulated from misunderstanding it. Why does this matter? Because public safety depends on clarity, not confusion. Because legal uncertainty increases financial and personal risk. And because long-term cannabis policy in Virginia will continue to evolve based on how these cases are interpreted, enforced, and challenged. Misunderstanding the law doesn't just affect individuals, it shapes future regulation. So here's the scenario, step by step. 2 drivers. Same THC blood levels. 1 conviction. 1 dismissal. The difference is not the number, it's the evidence connecting that number to impairment. That's the silent legal question people don't realize they're asking. And now, you have the answer. If you want to go deeper, the next video breaks down how drug recognition experts influence cannabis DUI cases in Virginia, and where their assessments hold up, and where they fail. So here's the question to think about. If impairment, not presence, Is the legal standard? How should Virginia balance enforcement with scientific uncertainty? That's a conversation worth having. Thanks for being part of Norfolk, Virginia Cannabis Hub. If this helped clarify Virginia cannabis DUI penalties and court cases, like the video, subscribe for future legal breakdowns, and join the Norfolk City Cannabis Community for deeper, local discussion, always compliance focused, always law first.